Terrence County Court at Law number 2 is back in session, included in session with its jail review docket. Next case, we have 5 cases. First case is cause number 23CCCR 1320. Second case is cause number 23CCCR 1348. Next case is cause number 33CCCR 1366. And fourth case is cause number 23CCCR 1367. And the fifth case is cause number 23CCCR 1368. All 3 cases are styled the state of Texas versus Brandon Jamad Bonton. Mr. Bonton, is that your full name?
Yes, sir.
Mr. Bonton, would you please raise your right hand? Mr. Bonton, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Bonton, you may put your hand down. How are you doing, Mr. Bonton?
I'm blessed, man. Take it one day at a time.
Well, that's good. You could not be better than being blessed. Now, Mr. Bonton, you're here represented by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
Mr. Boudreaux, do you waive a record in Mr. Bonton cases?
Yes, sir.
Mr. Bonton, in cause number 23CCCR 1320, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office, and in this information, it alleges that you, Brandon Jamad Bonton, on or about June 30th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Bonton, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Bonton, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you pleaded no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Bonton, I also have before me a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature on a line next to a box that's checked no contingent, which means no contest. You place your signature on this document?
Yes, sir.
On page 3 of the same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And Mr. Bonton, before you signed and initialed these documents that I just showed you, did your attorney, Mr. Boudreaux, go over these documents with you?
Yes, we did.
And did you read and understand everything that Mr. Boudreaux went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Bonton, are you a citizen of the United States?
Yes, sir, I am.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment, and State's Exhibit Number 2, the probable cause affidavit. State, would you like to offer State's Exhibits 1 and 2 into evidence?
Yes, sir.
Any objections?
No, sir.
No objections. State's Exhibits 1 and 2 will be admitted in the evidence court. We'll take judicial notice of State's Exhibit Number 2, which is in the court's file. Mr. Boudreaux, you've advised in counsel, Mr. Bonton, is there any evidence that Mr. Bonton is currently mentally incompetent in this case?
No, sir.
And Mr. Bonton, your attorney, Mr. Boudreaux, has advised and counseled you. Are you satisfied with his representation?
Yes, sir, I am.
Has he provided full, effective, and competent legal representation?
Yes, sir, he does.
Mr. Bonton, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do.
And what is that agreement?
Exchange for plea of guilty of contest, state's agreed to offer 50 days in jail and court costs, defendant has credit for 50 days. It has to be time served and tax and retirement court costs. Well, this case will also run concurrent with the two companion cases.
Mr.
We are
Bon,
dismissing two other companion cases.
okay, now, Mr. Bonton, the state is offering that you serve 50 days in the Jefferson County Jail. However, you would not have to serve 50 days in the Jefferson County Jail in this case because you've already served 50 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. And what that basically means is you will not be required to pay the court costs because the time that you have spent in jail has already paid the court costs. This case will run concurrent with cause numbers 23CCCR 1348 and cause number 23CCCR 1366. And the state will also be dismissing the companion cases, cause number 23CCCR 1367 and cause number 23CCCR 1368. Mr. Bonton, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir, it is.
And do you accept the state's offer?
Yes, sir.
Mr. Bonton, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Bonton, we will move on to your next two cases. And your next case is cause number 23CCCR 1348. And in this case, the state has also filed a motion to, the state has also filed an information. And in this information, it alleges that you, Brandon Jamal Bonton, on or about July 10th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Bonton, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Bonton, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily in this case?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay, Mr. Bonton, I also have before me a document that is titled misdemeanor plea admonishment. Do you recognize this document?
Yes, I do.
And on page 2 of the same document, there's a set of initials on the line next to a box that's checking over contentory, which means no contest. Did you place your initials on this document?
Yes, I did.
On page 3 of the same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
On the next document, that's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
And I also have a document that is titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And before you signed and initialed these documents, did your attorney, Mr. Boudreaux, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me states exhibits 1 and 2. State, like the officer exhibit 1 and 2 in this case?
Yes, sir.
Any objections?
No, sir.
No objections. States exhibits 1 and 2 will be admitted. Court will take judicial notice of states exhibit number 2, which is in the court's file. And Mr. Boudreaux, you advising counsel, Mr. Bonton in this case as well. Is there any evidence that he's currently admitted in competent trial? And Mr. Bonton, your attorney, Mr. Boudreaux, has advised and counseled you in this case as well. Are you satisfied with his services in this case?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Bonton, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, you know,
And what is that agreement?
and plead guilty to the contest, state degree recommend 50 days in Jefferson County Jail on court. And if it has credit for 50 days, also court costs would be there. We ask time served, this and tax or court costs. This will also run concurrent with the previous case.
And we
And
just,
another call.
okay.
And
Okay, now, Mr. Bonton, the state is offering that you serve 50 days in the Jefferson County Jail on this case. However, you would not have to serve any time in jail on this case because you've already served 50 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that you would not be required to pay it because the time that you have spent in jail has already paid it off. Therefore, it will be taxed and retired. This case will run concurrent with cause numbers 23 CCCR 1320 and cause number 23 CCCR 1366. As mentioned earlier in the previous case, the state will be dismissing cause numbers 23 CCCR 1367 and cause number 23 CCCR 1368. Now, Mr. Bonton, do you understand the state's offer in this case?
Yes, sir.
And do you think that the state's offer in this case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Bonton, I'll follow the plea bargain agreement that you have entered into with the state. The court will move to the next case that you have, and that case is cause number 23 CCCR 166. Excuse me, cause number 23 CCR 1366. And in this case, Mr. Bonton, the state has filed an information in this case. And the information in this case alleges that you, Brandon Jamon Bonton, on or about July 17th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Bonton, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now you,
Oh, no
no
contest.
contest? Now you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
And Mr. Bonton, I also have before me document that is titled misdemeanor plea of management labeled as State's Exhibit Number 1. Do you recognize the document in this case?
Yes, sir.
On page 2 of the same document, there's a signature on the line next to a box that's checked no contingent. Did you place your signature on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, it's titled trial court certification of defense right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
And I have before me a document that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant?
Yes, sir.
And before you signed and initialed all of these documents that I just showed you, did your attorney, Mr. Boudreaux, go over these documents with you?
Yes, sir.
And did you read and understand everything that Mr. Boudreaux went over?
Yes, sir. I do.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, would you like to offer State's Exhibits 1 and 2 in evidence?
yes, John.
Any objections, Mr. Boudreaux?
No, sir.
No objections. State's exhibits 1 and 2 will be admitted in evidence. Court will take judicial notice. State's exhibit 2, the probable cause affidavit, which is in the court's file. And Mr. Boudreaux, you advised and counseled Mr. Bonton in this case as well. Is there any evidence that he's currently mentally incompetent to stand trial?
No, sir.
And Mr. Bonton, your attorney, Mr. Boudreaux, has advised and counseled you in this case. Are you satisfied with his services in this case?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Bonton, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I'll also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
The exact same plea agreement as with 2 previous cases, been a plea guilty or no contest. We get 50 days and in Jefferson County Jail and court costs. He got credit for 50 days. This will be time served. That's back on the trial.
Okay, now, Mr. Bonton, the state is offering that you serve 50 days in the Jefferson County Jail. However, you're not required to serve any more time in the Jefferson County Jail. On this case, because you've already served 50 days in the Jefferson County Jail, therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court cost because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. And this case will run concurrent with the previous 2 cases, clause numbers 23CCCR 1320 and clause number 23CCCR 1348. And the state will be dismissing clause numbers 23CCCR 1367 and cause number 23CCCR 1368. Now, Mr. Bonton, do you understand the state's offers?
Yes, sir.
Do you think it's fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Bonton, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Bonton, you're going to stand next to your attorney in front of the clerk and follow her directions. Once you finish following her directions, you can follow the bailiff, and you have a blessed day.
All right, you too, sir.
You're welcome.
Thank you.
And Mr. Boudreaux, this is your last 5 cases. You're free to go, and you have a blessed day.
Thank you, sir, and you do the same.
Thank Jefferson County Court Law number 2 is back in session. The court is in session in cause number M333842. Case of style, the state of Texas versus Trevor Burge. Mr. Burge, is that your full name?
Yes, sir.
Mr. Burge, would you please raise your right hand? Mr. Burge, did you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
Mr. Burge, you may put your hand down. How are you doing, Mr. Burge?
I'm okay. I'm blessed.
That's good. Can't be better than being blessed. Now, Mr. Burge, you're represented in your case by your attorney Nathan Reynolds. Attorney Reynolds, how are you doing?
Doing well, Judge.
And Attorney Reynolds, do you waive a record in Mr. Burge's case?
So wait, Judge.
Mr. Burge, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that on or about October 25th of 2023, while you were in Jefferson County, Texas, October 25th of 2022, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of violation of a protective order. Mr. Burge, do you understand what you have been charged with?
Yes, sir.
And to discharge, Mr. Burge, how do you plead? Guilty, not guilty, of no contest?
Yes, sir.
Now, you're pleading guilty freely and voluntarily,
Yes, sir.
and are you pleading guilty because you are guilty?
Yes, sir.
Mr. Burge, I also have before me a document that is titled Misdemeanor Plea. Mine should also label the state's exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials, TB, on the line next to a box that's checked guilty. Did you place your initials on this document?
I did, sir.
On page 3 of the same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
It is, yeah.
And at the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
I do, Your Honor.
And I have before me a document that is titled Discovery Certification. You recognize this document?
Yes, sir. Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Burge, before you signed and initialed all of these documents that I just showed you, did your attorney, Mr. Reynolds, go over these documents with you?
Yes, sir. He did.
And did you read and understand everything in these documents?
I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Burge, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1?
Yes, sir.
Any objections?
No objections, sir.
No objections. State's Exhibit number 1 will be admitted. Mr. Reynolds, you've advised and counseled Mr. Burge, is there any evidence that he is currently mentally incompetent to stand trial?
None to my knowledge.
Mr. Burge, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Burge, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
Change for plea of guilty or no contest, state agreed to offer 1 year deferred adjudication, community supervision. I believe $100 fine,
Yes, sir.
$100 fine, 4 calls, 40 hours community-based service. All other standard terms and conditions, this will run concurrent with a felony probation. We didn't put that on the document, Judge, because it'll run current automatically. But
Okay.
we don't need to, we've had a problem with putting felony numbers in if they're not correct. So I'm avoiding that problem. It automatically runs concurrent.
Okay,
Because if the felony court wants to put, they didn't put it on there, it doesn't matter, it runs concurrent. For us to put it on, it means we run into a problem. If it's the wrong billing number, then there's a problem. So
Okay.
we're relying on that it runs concurrent no matter, there's not a way.
Now, let me ask you something. He was on the jail run list, right?
No, sir. No, sir. He's on bond.
Well, he was.
Oh, he's on bond. Now, were you court appointed?
No, sir.
Okay,
It was an add-on because of his felony case, and that's when they could add him on next door, so they put him.
oh, okay, so it's not a case you was appointed on,
No, I was
hired, oh, okay,
And so since his felony case was disposed of today.
okay.
We requested it be added onto this document.
Okay.
To dispose of this.
Okay.
One, so.
What's the court cost in this case? 337. Okay, let me do. And he doesn't have to pay that, family policy.
Felony terms of work control, I mean, it's the same, this one record current, there's not any extra thing we're adding on, other than 40 hours community service, but if you do 40 hours, it'll count on both cases, felony and here, it's not like you add them on top.
Let me do this here. Is there like a no contact or anything in here?
That was.
If it has to do with the felony case, does it's not before this court, we're not putting no contact on our.
Oh. Okay, I don't even see it. It was just say a violation of protective order. They didn't even have a victim's name in here. Oh yeah, they got an Erica Burge. Was the who's protected? That was the victim.
Do you have that in the?
Well, no, see, they're married and they're reconciling. That was part of our deal that they not impose a no contact on their probation.
If they're married, I'm relying on what counsel saying as part of that deal with the felony stuff. We're not gonna put it on there and make it, you can't have any contact with his wife he lives with.
Okay, I just wanted to make sure we had understanding of that.
Yeah,
We do, but we don't need to add anything onto a misdemeanor probation that the felony didn't take care of.
No, but I'm just saying, anytime you have, I don't know what
For sure.
that case was about. Case is like, it's kind of like,
they're related, Judge.
yeah, okay, I didn't know anything about
I
that.
didn't
So
know, I was told today.
Have something in his Barnes Court.
I understand. That's what this protective order is. Okay, so Mr. Burge,
Yes, sir.
the state is offering that you serve 1 year deferred adjudicated probation.
Yes, sir.
During this 1 year probationary period, you'll be required to pay a fine of $100 plus court costs of $337. You'll also be required to pay a probation fee of $60 each month, your analysis fee of $15 each month, and a reimbursement fee of $15. Now, the total amount in the installments is $123. But I should inform you that because you are already on probation, it's in this county.
Yes, sir. It's next door, Judge Stevens.
Okay. You will only be required to pay one probation fee. So they're gonna reduce this by $60, and then you'll be required to only pay a reimbursement, the $15 each month reimbursement fee. So in essence, they're gonna reduce the total monthly installments of $123 by $75. So you'll probably be paying somewhere in the neighborhood of $48 a month on this program. Do you understand that?
Yes, sir.
And you'll also be required to perform 40 hours of community service. You will also be required to adhere to the other standard terms and conditions of disprobation. Do you understand that?
Yes, sir.
Now, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
For the felony, yes, sir.
Well, what about, do you have two cases? I'm not asking you about a felony. I'm asking you about this case.
I do, Your Honor.
Okay, and do you accept the state's offer?
I do, yes, sir.
Do you accept the state's offer?
Yes, sir.
Okay, now, Mr. Burge, the court is going to follow the plea bargain agreement that you've entered into with the state. Now, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney, Mr. Reynolds, about the non-disclosure because he's quite competent in those matters. Now, Mr. Burge, also you should have a document before you that is titled Model Written Ammunition on Ineligibility to Possess Firearm or Ammunition. I'm going to go over this document, and it reads as follows. In accordance with the Texas Administrative Code, section 176.1, the court hereby admonishes you or warns you of the following. Number one, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code section 46.013, A, firearms mean any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife, blade, or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective order. Now, Mr. Burge, the document that you have in your hand is for your records, the ammunition. You're going to stand next to your attorney, follow the directions of the clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. Thank you.